registration by the government. As soon as you create a copyrightable work, you have a copyright on it. Registration is optional, but beneficial if you want to create an official record in the Register of Copyrights. Every country has its own laws on registration, like the Copyright Act 1957 in India. Copyright is a bundle of rights, as it gives a combination of rights to its owners. For example, the right to make copies of the work, storing it, and even adapting it. Then, there are neighboring rights, which give certain rights to broadcasting organizations and performers. Moral rights give integrity and paternity rights to authors and performers in their works. These rights last even after the assignment of economic rights. Remember that there is no copyright in ideas, procedures, methods of operation, or mathematical concepts. The biggest takeaway is that you can only copyright expression of an idea and not the idea itself. Originality is to copyright what distinctiveness is to trademarks. It means that the criteria of protection under copyright law is originality. As we know, source code and object code of a software can be copyrighted. In this context, we have learned about open source software, OSS. OSS is software with a source code which is open for anyone to see, inspect, or modify. The term of copyright protection varies with different categories. After expiry of this term, the work comes into public domain. Moving to industrial designs, it protects the aesthetic features of a product, which are visible to eye and which can be reproduced with the help of an industrial process. Think of a high-end premium design for a fitness tracker. Only a design which is new or original is protected. Registration is compulsory for design protection and lasts for 10 years. You can renew it for a further period of 5 years.
Namaskar and good evening to all. A quick check. I hope I'm audible.
Yes, sir, you are audible.
So again, I'm thrilled to welcome you all today to L2 Pro workshop on copyright protection and challenges for startups and MSMEs in the age of digital AI. I'm your host, Nitin Sharma, and I have the pleasure of working at Qualcomm as Technology Council, overseeing various IP initiatives in India. We have initiated this webinar series to engage with you all on the fascinating field of intellectual property. We are in the century of intellectual property, and for any country that aims to aspire to make a mark on a global economic stage, IP plays a very crucial role. And we are seeing the importance of IP and technology leadership as every day goes by. Right? Through this webinar series and the L2 Pro program platform, our goal is to spread awareness about intellectual property rights in India. Today's webinar promises to be particularly engaging as we will dive into the copyright protection and related challenges presented by the distinguished speakers, which I'll introduce them shortly. Now, this series is brought to you by L2 Pro platform, which stands for Learn to Protect, Secure, and Maximize Your Innovations. Is my screen visible?
No, sir, it is not visible.
Okay. Please confirm. I have just shared it.
Yes.
Okay.
No, it is visible.
Okay. So basically, as I said, this series is the L2 Pro stands for Learn to Protect and Secure. When we started our startup program, we interacted with a lot of startups, and we realized that there are a few startups which are very well versed with the IP and IP strategy. But then there are quite a lot of startups which needed handholding in building a good IP strategy. That kind of led us to create this platform, which is primarily meant to give a very basic primer on intellectual property, how one can build a good IP strategy. This aligns with the government policies of Startup India and Make in India. This effort is in collaboration with the DPIIT and CPAM, along with NLU Delhi. Now, this course comes to you in two forms. One is the L2 Pro India website, and the other format is the Android app. Now, this course is, as I said, it aims to provide an awareness and understanding around intellectual property, typically about how do you protect your innovations, how do you use copyrights, trademarks, and integrate various IP considerations into your company business models, right? Um, this has three levels of three modules, let me say, three different levels. One is the basic level, which covers the fundamentals of IP. All types of IP protection mechanisms are covered there. The intermediate level talks about NDAs, restrictive covenants, and filing and acquisition of IP, a bit on commercialization, and also around how do you do IP searches and freedom to operate exercise. The advanced level then delve into the topics like funding, venture capital, access to venture capital funds, how does SSOs work, etc., and also to some extent on dealing with disputes, invalidity, infringement, and so on and so forth. As I said, it also is available through a mobile app, which can be accessed through Play Store. It comes with introductory video followed by the description and details on that particular topic. It also has certain set of questions that pops up to check your intermediate learning. And basically, towards the end, you get a certificate which is co-signed by NLU Delhi, CPAM, that's DPIIT, and also Qualcomm. And it has a QR code, so everybody gets a unique certificate. So with that, I would like to then introduce our first speaker and dive into the interesting topic of copyrights. So our first distinguished speaker is Lakshika Joshi, Senior Director, Global Risk and Compliance, Head of Contracts Management and IPR Rights at Harvard Business School Publishing. Lakshika is a seasoned technology lawyer with 20 plus years of global experience in legal risk, compliance, commercial contracting, IPR, and digital innovation law. At Harvard Business School Publishing, she leads contract management and IPR programs, shaping framework for emerging technologies like generating AI, blockchain, and digital rights. Previously, Lakshika held leadership roles at Capgemini, Edison, Altran, and Times of India Group, driving global legal and licensing strategies across APAC, Europe, and the Americas. Her work has influenced legal policy and IPR monetization for software, media, and content in regulated industries. She advocates for IP education, serves on international boards, including LESI, and mentors future professionals as guest faculty at institutes such as SSIFS and ICFI and ICAI. Recognized globally, Lakshika has earned honors like Star Women IP Lawyer of the Year, Global Lawyer of the Year, IP and Technology, and LESI's Merit Award with listing in IM Strategy 300 and WTR Global List. Thought leaders, she calls herself a student forever evolving with law and technology. It's an honor and privilege to welcome you, Lakshika. Over to you for your session. Looking for exciting
Thank
details.
you very much, Nitin. Thank you for having me here to the L2 Pro platform and the organizers. It's a privilege being here today, sharing some thoughts and whatever I know about the domain, which is fast evolving and developing as we speak. Without much ado, let me quickly dive into the session, and I'll also give a quick background about how these slides came about to be. So these are just very quickly put sort of collated slides on this topic. I don't know if they do full justice because this is a topic which, as Nitin was explaining earlier, which goes all the way from basic understanding to some very deep level technical issues that are rising in the domain, more so with the rise of generative AI and how content and copyrights and software codes are now being created with not just human intellect, but also use of artificial intelligence. So if I can request to go on to the next slide, please, we'll straight away dive into the session. Thank you, Parul. So I just wanted to talk to all of you a minute about why copyright matters for all of us, and especially so for startups and MSMEs. You know, copyright plays a pivotal role in safeguarding original works, and we also saw it in the presentation that was made earlier, that it protects original works. So originality is the key. Now, these works could be software code, data sets, designs, and content, which are fundamental assets for startups and micro, small, and medium enterprises. In a rapidly evolving AI-driven digital landscape, intellectual property serves not only as a valuable asset, but also as a potential risk vector. Now, use of training data set, generation of model outputs, automated content creation, all of this introduces complex questions around ownership, infringement, and licensing. And for resource constrained, I should say, startups and MSMEs, establishing clear copyright strategies becomes extremely essential to mitigate legal risks, to enhance investor confidence, and also support sustainable growth for the organization. Now, this is particularly critical when products integrate proprietary content with third-party inputs and AI tools, making delineation of rights and responsibilities very challenging. So, by proactively managing copyright issues, these organizations such as yours, and even not just startups and MSMEs, but even larger conglomerates, can protect their innovations, maintain their competitive advantage, and navigate the legal intricacies of the digital economy effectively. So, can we move on to the next slide, please? Thank you. So those are some of the thoughts that I had on why it's become even more important in the world that we live in, which is totally digital and AI driven. And it also creates that differentiator that we need for our businesses to not just trigger the first few sort of cycles of investment, of customer centricity, but also for a sustainable growth. Now, what are some of the core principles that we should then be talking about or focusing on as organizations when we talk about copyrights in a digital and AI age? And in this rapidly evolving AI digital landscape, as I was mentioning before, copyright protection has become extremely critical concern for organizations. Copyright safeguards original works and software code, data sets, design, which are all essential for or core of what an organization may be building. So it is sort of important that we focus on. Sorry, please go back to the previous slide. Can you please go back to the slide before, the risk slide? Thank you. Now, what happens is copyright law traditionally grants protection to original expressions of human authors. Across the globe, we've seen in laws, not just in India, but the work has to be original, it has to be human generated, and it has to be fixed on a tangible medium. However, with integration of AI tools into creative and development processes, it has introduced some complexities. Now, when AI assists in content creation, the human contributor must exercise creative control and make meaningful selections for the output to qualify for copyright protection, because we've had numerous cases across the globe, across jurisdictions, where it has been held that a solely AI generated work does not qualify for copyright protection. At least that is the legal stance as on date today. And therefore, there has to be some kind of human intervention into that output to be able to qualify for copyright protection. Now, outputs generated, as I was mentioning, entirely by autonomous AI systems may not be eligible for copyright because it raises questions around ownership, authorship, and enforceability. Ownership of copyrighted works also depends heavily on contractual agreements, including what is the agreement between the employee and the contractor agreements. Is it a work for hire? Or is it a work where copyrights were meant to be assigned to the person who actually commissioned that work, and so on? So the contractual provisions also become extremely pertinent when it comes to ownership rules in copyright domains. These legal instruments must be carefully defined to avoid any disputes and ensure proper attribution and control. Additionally, different types of works, such as if it is a derivative work of the original creation, if it's a curated data set, if it's a software component like a source code or an object code, or if it's a documentation, or if it's a user interface, a UI. These are all subject to distinct copyright protections. Now, factors like moral rights, open source licensing terms, which we spoke of earlier in this discussion today, and jurisdictional differences also influence how copyright is enforced and how these works can be reused. So for specifically startups and MSMEs, navigating these principles is essential to safeguard their innovations and maintain a compliance, a healthy regime in a complex and fast developing and evolving legal environment. We can now move on to the next slide, where I want to talk a little bit about the risks that are involved with. Can we move on to the next slide, Parul? Thank you. So I want to talk a little bit about the key risks that are involved with use of or with the advent of AI and generative AI tools in creation of content and use of these tools for creating anything around business outputs or anything which plugs into business. Now, there are significant copyright risks when leveraging these systems is a given, particularly in context of training data sets and content generation. AI models that are trained on copyrighted materials may trigger infringement claims if usage exceeds the scope of licenses. There are fair use provisions that have to be kept in mind, and which in itself is a very complicated phenomenon because fair use relies on a four-factor test in the US. In India, it is interpreted more closely to fair dealing. UK interprets it differently, and there are some statutory exceptions that exist, specifically in India and in some other countries, on what will constitute fair use. Now, practices such as, scraping the online content without consent or embedding copyrighted assets into training data sets, all of this can lead to legal liabilities. Just about 3 days before, we had an interesting ruling from a regional court in Munich, Germany, where they said that GEMA, GEMA, which is a society that administers music rights for some of the German lyricists, was granted damages in their favor against OpenAI, because the court in Munich held that OpenAI, by scraping their content, by scraping their music lyrics, did not indulge in a fair practice, in a fair use, if I may say so. And therefore, these plaintiffs should be granted damages and should be entitled to damages for use of their lyrics by OpenAI. And the court also said that this is against the principles of, so even the principles of text and data mining exception that exist in EU were not upheld for this particular matter. So sort of going back to the practices of scraping online content, I think we are still seeing where law evolve across the globe, and we still don't know how these things, well, this is the recent judgment from 3 days back, but about 2 months back, we had an interesting judgment in the US in the Meta case, where the court said that if the content that is used for training or the data sets that are used for training, if they are legally sourced, then it's all right to use them. So these two rulings on their own seem very conflicting. And therefore, the laws are still evolving on it. We don't have one consistent position in any country as of now. So it's always good to be a little cautious and err on the side of caution when we're using content which is created or generated using Gen AI, because they may have trained their they may have trained their models on data sets which were not legally obtained, and that in itself then goes towards contributory infringement. So that's another risk. And not just this, another risk that AI generated outputs may have is that they mimic the style or content of existing copyright works. When I say mimic the style, I don't know if you all remember that recently we've had a judgment from the Delhi High Court where there was an injunction granted to a particular party was using content in the style of Anil Kapoor. And Anil Kapoor went to the court and sought an injunction saying that they are mimicking my style of dialogue delivery. Now, that in itself was sort of held enough to grant an injunction, because, and therefore what I'm saying is that the AI generated content may also mimic the style of an existing copyrighted work, and that could be potentially infringing and result in unauthorized reproductions or unauthorized use of content, style, and therefore is something that we need to be careful about. Now, there are techniques like watermark removal or bypassing content filters. These are also some techniques and things that exacerbate these risks, because many of these AI tools may have used these when they sort of scraped through the web and used all of that content to train their models. So then on top of all of this, there is the whole piece around terms of service, which is provided by AI model vendors, which often limits indemnification and shifts the burden of legal risk to the users, to the end users, which means that organizations must be very vigilant about provenance of AI outputs, especially when used in public releases, demonstrations, or marketing materials for that matter. Now, ensuring a clear documentation and understanding of content origin, how content was obtained, the sources, it's crucial to minimize the exposure and avoid legal disputes, and these can be extremely expensive and costly. So that is a huge risk that we are seeing across the globe, not just in India, with having to just use AI to create content and incorporate that into your marketing materials, into your advertising, your promos, and things like those. We can move on to the next slide, please. Thank you. So that gives you a real sort of a quick glimpse into some of the risks. But having said that, there are ways that you can effectively sort of manage some of these risks in the AI and digital environment. And these can be managed through various steps. And here is what I've listed as some of those steps. So the first is when you establish a written IP policy within the organization or within your startup, which encompasses some guidelines for data sourcing or content sourcing, the model usage, and the content review processes. So if there is always human in the loop, you will be able to also sieve through some of these risk areas and actually get to a piece which is filtered for anything that may create a risk for the organization. Then maintaining detailed provenance logs for training data, for the prompts that were used, for generated outputs. It ensures traceability and accountability. It's extremely critical if, let's say, you're creating a software code using a Gen AI tool. Now, the code which is created by the AI tool is clearly not copyrightable. So how do you then protect the entire code piece? So I think what's important is that you keep a record and a log of the inputs that were given, because those were creative and those are your inputs, and those could qualify for copywriting. And therefore these training data, the prompts that you made, and then vis-a-vis those prompts, the corresponding generated outputs will generate a clear, traceable and accountable, sort of path for you to be able to claim ownership and proprietorship or copyrightability on that piece of code or that piece of content. Now, preference should always be given to licensed content or code which is consented, or internally generated materials to avoid infringement. Then there are ways to conduct thorough vendor due diligence, because you may be procuring some material from your vendors, and that also needs to go through a process to be able to see that they have followed this through. This includes reviewing their licensing agreements, output usage policies, their indemnification clauses, and any restrictions on content use. Again, before releasing any of the products or marketing materials, organizations should perform a pre-release reviews to ensure copyright clearance, utilize some automated tools. There are many that are available to detect if there is any copyrighted media in those. Then standardizing your contributor agreements. If it is, and this contributor could be a content contributor, could be a software contributor, could be a vendor, could be a coder, including what is your agreement with the person? Is it a work for hire? Does it have proper assignment clauses? Does it help to clarify ownership in that agreement to prevent any future disputes? So open, again, we talked about it slightly earlier, but open source compliance should be maintained through software bill of materials and your license scanning tools. Additionally, what I suggest is to be considered is registering key works where it is possible. So whether you apply watermarks on the content, you put copyright notices, that is important, because that also demonstrates, and that also is your notice to public vis-a-vis that work, that it belongs to, or you are the proprietor of that work. This also speaks to deploying some takedown and monitoring workflows to address if there are online infringements of that work. Now, these measures collectively strengthen the organization's copyright posture, and they reduce legal vulnerabilities. This is just a really bird's eye view of the things that can be done, given the paucity of time and the limitations that we have today. But these should give you a sense into, if you dive deeper into each of these practices, should be able to create some kind of a robust working model for you, where at least you're protected against any copyright infringements of your work, and also you wouldn't involuntarily or inadvertently infringe any third party's work. So can we move on to the next slide, please? So these are some of the practical protections that I was sharing. Now with that, we are moving on to what kind of strategy and governance we could have for balancing innovation and compliance. Because from all these practices that I spoke of earlier, it looks like all the time is going to be spent in compliance and governance. So where will we have the time to innovate? Now, that's actually a question that all of us ask all the time. And every organization that has been successful, every organization that works with IP and IP systems or products and offerings that create intellectual property need to balance it. So building a resilient copyright strategy requires to integrate governance mechanisms that balance your innovation with your legal compliances. This begins with establishing a board level oversight for intellectual property risks or copyright risks, and which means then that you conduct periodic audits of data sets, of the source code, of the content assets that you have. Documenting decisions related to fair use and statutory exceptions also ensures transparency and defensibility, because then you will have a track of how you arrived at certain position and why you decided to do or not do a certain task in vis-a-vis launch or not launch and things like those. Now, product design should be also duly calibrated to minimize any reliance on high risk inputs, or you should favor modular licensing approaches, isolate any AI generated outputs from core proprietary IP whenever necessary, because that is where the risk will be. Now, with that, we come to how do we do infringement management. So organizations must also set up a clear escalation path for if there is any infringement claim that needs to be handled, and negotiate your vendor agreements and include robust indemnity provisions, and have a documented set of guidelines to be able to address all of these points. Now, quantifying your potential exposure and communicating it effectively to investors can also boost investor confidence, their trust, and it can support funding efforts. So, importantly, copyright should be viewed as part of a broader IP strategy that includes trademarks, trade secrets, patents, and contractual protections. And aligning your copyright practices with ethical AI principles further reinforces your brand integrity and public trust in that brand. So, embedding these governance practices into your operational framework, you can innovate confidently while maintaining compliance and governance and protecting the intellectual property assets that you have. So, this is a very short sort of glimpse or a quick glimpse into the main points I had for today, Nitin, and all of you, on how I think we should be managing some of the copyright risks that we see in day-to-day operations versus, what are some of the long-term practices and strategies that organizations should adopt, especially the startups and MSMEs as they're establishing businesses and brands, for copyright governance and for copyright, clearances, for copyright practice within that organization. With that, I'll pause here and do a quick check if there are any questions, if there's anything that I can help with.
I guess we'll take the questions in the end. I don't see, or is there anything? 1 second, let me check. Okay, so maybe let's take the questions towards the end. Let's move on to the next speaker. But before that, thanks Lakshika. I think this was a very interesting and engaging conversation and details that you presented. So let's move on to our next speaker, Dr. Ragini P. Kubalkar, Associate Professor of Law, Chairperson, Professor at DPID, IPR Chair, Head of Center of Intellectual Property at MNLU, Nagpur. Dr. Ragini specializes in intellectual property laws and holds PhD on protection of copyright law, national and international perspectives. She completed LLB, LLM in commercial laws, LLM in IP laws, and MA in economics, and also cleared UGC NET in law in 2009. Before joining MNLU in 2016, she taught at GWCL Nagpur. At MNLU, she heads the Center for IPR, serves as DPIIT Chair, Professor, and convenes CDC. She has organized numerous national seminars, workshops, and WIPO India summer schools, and frequently delivers lectures as a resource person and judge at legal events. Her contributions include research articles, book chapters on IP and gender justice, and leadership roles such as editor of CLR Journal, former chairperson of ICC, and faculty advisor for Legal Aid and ADR Society. She is a member of the Ministry of Commerce Committee for FTA negotiations and Global Alliance of Justice Education. An honor and privilege to welcome you, Dr. Ragini. Over to you.
Thank you. Thank you so much, Nitin. So first of all, good afternoon, all of you. And I'm listening to ma'am, and Lakshita ma'am has covered very well the practical approach with respect to MSME and copyright issues. particularly in this digital age. So my half work has been done by her, but I'm totally into academics. That is what you can read out from my biodata. Okay, so I'm going to share the provisions and the case laws which are important and which basic concept should be clear to these startups. That is what they should remember, and they should continue with, they should ponder upon whenever they are starting their startup. That is what I'm going to share today. Okay, I'm just sharing my PPT. Yes, I hope it is visible to you.
Yes, ma'am, it is visible.
Okay, okay, thank you. Yes, so when we are talking about copyright protection and challenges for startups, here what I have identified that first we have to understand what is actually copyright protection, and the video which has been played by ma'am has give us good idea about copyright. But still, I will be speaking little bit about this copyright issues also first. What exactly copyright is? That is what should be very clear in our mind. So whenever we are, that startups particularly, whenever they are starting it, they decide something. They decide about designs. They decide about the um, how they are going to proceed, and whatever matter they are writing, they have copyright into that. They have copyright into computer programs, they have copyright into softwares. Okay, but they have to remember that when we are talking about all these things, what exactly copyright is. See, copyright is talking about original work. So original work, and if you go into the bottom of the act, you will see they are talking about, all the provisions are talking about only with respect to human creation. Okay, we were not mentioning very precisely. So for that matter, whenever you are starting your work, I will be asking you to go and check the some of the provisions, okay, which everyone should aware of it. So copyright act is talking about author. Okay, protection is given to author. Okay, there is a concept of authorship, ownership, that is different. That is the ahead next step we are talking about. But when we are talking about author, section 2A of the Copyright Act of 1957 very clearly talks about it. And amongst them also the sixth one, which talks about in relation to literary, musical, dramatic, artistic work, a person who causes the work to be created and make arrangement, okay, with respect to computer program. That is what very clearly provided over here. So now we are talking about digitization. That's why I am taking you directly to the sixth clause of section 2, okay, 2A, which defines author. So there also you will see that the definition of author says that the person who causes the work is going to be treated as author. Okay, so here also we can see that the whole act, the whole provisions with respect to copyright is specifically talking about protection of human creativity, not the machine creativity, not specifically,
Yes,
but
ma'am.
with the precision.
Your
Yes,
slides are not moving, ma'am.
yes, yes, I'm on the copyright slide only.
Yes, yes, yes.
I'm on that slide only. Okay. So first I will talk about it, and then I will be moving ahead. I am also having only 6 slides. Okay. Heading I have put over here, and I'm going to talk about it. Okay. So when we are talking about this, copyright protects original creativity work, including software code or user's interface and documentation. Here we have to understand what exactly it and who is the owner of it. If that is clear, then we may not make mistakes into taking some material which is available on the internet or anywhere. So that precaution has to be taken by author. Okay, or that precaution is to be taken by owner of the person who is starting with any micro or medium startup. Okay, so what exactly original creative work? That is originated from a human being. Okay, that we have to remember. And there are number of cases which talks about it is not only skill, labor, and investment we are talking about, economic investment we are talking about, that was the sweat of the brow principle, but we have moved ahead and we have incorporated the principle of modicum of creativity, which was established in the case of paste publication. Okay, and we are now trying to find out what is contribution of that additional contribution, minimal contribution into that creativity, and that is what we are trying to extend this copyright protection. And of course, software is coming into that, designs are coming into that, creative content, that is also coming into that. And that's why it is very important to understand the meaning of copyright. Okay, so originality, for that also we can refer to number of Indian cases. And the first on that is this A.G. Anand's case, okay, sorry, R.G. Anand case, where this principle of creativity, human creativity has also considered while discussing about idea expression dichotomy. Okay, so to my student, I always give one example which I want to share over here to understand simply what is exactly creativity is and which creativity this copyright protect. So you imagine from literary point of view, when the students are writing answer to the question, okay, if suppose I am teaching into class and referring only to one book, 5 articles, everybody is getting those articles, getting those books, reading the book and going to give exam. Okay, so definitely what will that, within that framework only answers will be there, but whenever the students, 100 students are writing the answer, their way of writing, style of writing and presentation, everything is going to be different, and that is what protected original expression, that is what protected under copyright. So whenever you are doing such activity, again we have to refer to section 13 also, where it has been very precisely provided which subject matter is protected under copyright. Everything is cannot be protected. Like for patent also, we have to refer to section 3, invention. Okay, definition of invention, section 2J. Unless and until that is clear, if that is not coming into that, we cannot proceed further. And if subject matter is coming under section 3, then also we cannot grant patent. In the same manner, when you are referring to the copyright, our concept should be very clear. What is exactly copyright? When can we ask for copyright? For which innovation, which creativity will give us protection? Exclusionary right will be given by registering our work. Yes, copyright law provides that there is no specific need for registration. But at the same time, we have to remember that if we register it, then definitely it's a conclusive proof which we have, evidentiary proof which we have, can be supported for our any infringement suit or any damages, whatever claims we are making, that for that this will be a conclusionary proof. So that's why registration is needed for it. So what I was talking about, originality. So originality in that way. So here I have given you the example of literary work, and this original word is prefixed with only 4 type of work, that is literary, musical, dramatic and artistic work. Okay, and then the 2 more works added over there, that is cinematography and sound recording. And when we are talking about computer program software now, because these are the things after digitization, we are working on that only, softwares, right? Subject code, object code. When we are doing this, we are writing something. Okay, the program has to be written in a different language. Okay, so that is what, that is we are creating software. So writing is covered under copyright. The amendment has been made in 1994, and in that way it has been included, because before that it was not a subject matter or to be considered, as there was no litigation as such crop up in India. And that's why you will see slowly we have amended our provisions and add on. Okay, and now with the advancement of technology, we are struggling with artificial intelligence, and that's why these issues are coming, because artificial intelligence is again and again talking about open source, open information, because see, Copyright Act is also based on that dissemination of knowledge that should be there. That is what artificial intelligence is also trying to take help, trying to take help of pleading this argument, like it was happening in ANI and OpenAI case. Okay, their argument was like that only. So we have to remember that why this act has been introduced. If you go to international instruments, like here, I just want to refer TRIPS agreement, Berne Convention. You see that they are also talking about originality. Okay, the provisions are talking about humanization. Okay, Article 10, you read, you will come to know that they are somewhere talking about, though they are talking about data, you can read out the provisions of protection of copyright from there also. But humanization is the interest which Copyright Act is protected, talking about. So here, basic principle which we have to remember is that when we are talking about copyright, the first and foremost thing is that it is not a natural right we are talking about. It is a right which has been protected through statute. Statute has given this right. Okay, it's not a fundamental right. Yes, we have made laws because of constitutional provisions only, but still it has been statutorily created rights. Why these rights has been created? So that we want to protect our artistic work or literary work, and that, for that their protection we have created these rights. And we have to maintain the balance. If you read the provisions, you will see that in number of provisions we have created that balance also, so that if there is a conflict of public and private interest, then definitely public interest will be given priority. And that is what everywhere we are talking about in all the cases which I have written over here. There also you will see that in all the cases we are, court or judiciary is actively playing the role and talking about protection of public interest. Okay, yes, of course, protection of public interest is also there, but when we are creating something, if we are not protecting the creator's right, human creativity, then why human will create something? Always we want some boost for creating something, and that boost, if it is not incentivized, not recognized, then definitely we do not want to share that innovation with our friends, with many people. That will not possible. And that is what core principle of copyright law, that it is maintaining that balance, protecting creativity of human as well as giving knowledge, dissemination of knowledge to the public. And that's why whenever you will see, the number of cases are talking about such provisions only. So Article 38 is also important of the Constitution, which talks about social order, okay, which is based on justice. Then Article 39B, which talks about ownership, that is also important. Then some reflections with Article 21 also can be considered over here. Apart from that, when we are talking about national IPR policy, okay, for that time also, without creating means emphasize on only on emphasis has been given to balance the rights of creator on inventors and public interest. UGC guidelines are also there, where they are talking about promotion of research, and for that they are saying that promotion of research, when we are talking about, we have to give respect to those researchers. Okay, how we are going to give respect? By recognizing their work. So when we are doing this starting up with some micro or macro, micro or some other startups, we have to remember that we should not leverage upon somebody's knowledge. We have to give due recognition. And for that, I'm not going into details with procedural part because ma'am has very well covered it. Because when it comes to licensing and other things, she has very well discussed about it. But I'm discussing the provisions which we have to read out, which we have to understand. As a layman also, we have to understand. And we have to help the people to understand all these terms, because we know that law has its own jargon. And that is what difficult for a layman, common man. So we have to help them to understand what is the basic intention for creating these particular provisions. So then only it will be possible that we will give justice to all. So digitization has been done for each and every work and through. So also in copyright also we can see that in all IPR types of IPR registration can be possible. And digital technology, knowledge of digital technology, digitization is very important, because by sitting here we can do business. And now we have business through digitization only. If we do not reach to that, then it will be difficult to reach each and every consumer. Okay, so for that reach, it is important. Further, okay, licensing, I'm not going to talk about it much, or other procedural aspect. So here we can see that Byju's first. Okay, so Byju's has strategically utilized section 14 and 17 of the Copyright Act. 14 talks about rights which has been provided under Copyright Act, that we have right to reproduce the work, create the work, and all other things. Okay, so economic right, particularly moral rights, has been discussed in the Copyright Act. It's provided in the Copyright Act only. Section 57 of the Act talks about it, but section 14 is a very important, which talks about copyright means. Okay, and there they have divided all these 6 types of subject matter, and with respect to each subject matter, which rights are available, that has been mentioned over there. So to protect our proprietary educational content, we can refer to this literary work, particularly 14.1, which talks about all these rights, reproduction, making copies. And see, when we are talking about those reproduction, adaptation, distribution, we have to understand the meaning of that also. What exactly meaning of right to make copy? What is reproduction is? If something is available on internet, it doesn't mean that it is available or free of cost. It's a material of somebody which has been uploaded. So when generally it happens that startup companies, while deciding about their trademark, what they do, they try to find out which image is very good and well connected with their business, with their startup. They try to implement or take those images and put on their startup. That should not happen. For that, trademark should be very clear to them. Okay, so we have to understand this. Whatever material is available on the internet, on the social media, on anywhere, that is not free of cost. It's a material of somebody else. So if at all we want to take it, then we have to enter into agreement. Okay, we have to take license for that. Then only we can use somebody's work. We have to understand in a different manner. Adaptation of literary work means exactly what? Translation of work means what? How we are supposed to exploit that? Those terms should be clear, and that is what this platform is working for, to understand the startups. All these, whatever syllabus has been introduced by Nitin sir, which I really appreciate. It will definitely help you to understand when you are starting your startup, that what are the things which you have to keep into your mind, because when we are seeing the disputes of infringement of copyright also, lakhs and crores of rupees are involved into that. So when we are talking about startups, definitely your capacity is not that much to resolve such disputes or such things. So we have to remember over there. Then when we are talking about the MSME, yes, of course, we have to remember copyright. Okay, that is, I refer to section 2, 13, 14, 17. Joint ownership talks about under section 17 of the Act, and certain provisions. Apart from that, there are certain provisions of contract, okay, which talks about agreement. With that also, we should well versed. Those are important while entering into an agreement. So contractual provisions are important. Then trade secret and confidential information is important. And when we are talking about digitization, Information Technology Act, that is also important. If we are committing some mistakes, what are the options available to us? That also we should know. So these are the four broad areas or laws with which we should be well versed when we are preparing for licensing. Okay, that is what I want to share with you. Then here I just want to talk about authorship ownership concept. Yes, it is very clear that when we are talking about artificial intelligence, nowadays we are not restricted to digitization, not digital content we are talking about. Now artificial intelligence is also creating something, and what about that? And that creation is based on our knowledge, based on the data which is available in public domain. Sometimes it is not in public domain, still means allegations are there that has been secured and used by OpenAI. So what is to be done? So see, we have to be very clear with the concept of authorship and ownership. Here I just want to give you one example. Take the example that if somebody is very well versed in our present webinar, who is good in painting, and I ask him to make my sketch, okay, and for that I'm giving him 50,000 rupees, for example, okay, whatever sketch he is going to make. So this is what I'm asking to do something, okay, on my direction. The action has been committed. So author of the work, the person who creates it, originality will come from that particular person who is going to draw the sketch. So he will become always author of the work, okay, but on my direction, on my contract, he is doing something against money. So by referring to contractual relationship, what ownership will always with me, okay, and that is what ownership authorship concept is. Okay, I think this is the best example to understand authorship ownership concept. And that will also help you that if you are giving some work assignment to somebody to make some logo for your startup, then how it will be defined, how ownership will be talked about. So all these provision with respect to authorship ownership has been discussed over there under section 17 and 18 of the Copyright Act. So whenever you are doing this, these are the important provisions which you can refer to. Okay, then further, yes, when we are talking about this artificial intelligence, okay, there is one interesting case happened in just a minute, Punjab and Haryana High Court in 2024, where the student has made assignment and submitted, which has been, for which he has taken help of artificial intelligence. Okay, and he was saying that on my prompt, assignment has been created by artificial intelligence, and it's the age of artificial intelligence, so we can use that. Okay, but the court and in that particular case, court has not considered his argument, of course, because that AI generated work to be protected, that is what he was saying. But when we refer to the core principles of Copyright Act, it says that human creativity is very important. Okay, and apart from, and for that matter, they have not given relief to it. It's a case of Kaustubh versus Jindal Law School. You must be knowing about it. And this has been failed to grant protection. Okay. And student has referred to section 2A 6 clause 6 for defending his argument. So no, I'm sorry, it was not decided by the court, that those arguments were raised by the student. Okay, but what happened? The matter was finally decided out of the court. So their court was not in a position to decide finally what is the result of it. Okay, further here I want to refer one more case. Just a minute. I should not forget, for that matter, I have written somewhere. Yes, in one of the case of M. Siddiqui, that was the case of 2019, where where the court has very clearly clarified that the copyright confirmation of legal personality by court is an innovation arising out of necessity and convenience that has been discussed, and they were clarified over there that legal personality has been taken care of, okay, over there. So when we are talking about legal personality, you may raise the argument that now artificial intelligence can be treated as a juristic person, like we consider to river, forest, and we have used it in some of the CSR, with respect to criminal cases against company. Okay, but when we are talking about that, there also you can see that the corporate well has been considered by the court, and then they have decided that who is really responsible for that liability, and then they have decided the liability. See, when we are talking about artificial intelligence giving right to them, at the same time we have to remember what about their duties, what about liability. Okay, jurisprudence is the important subject which says that rights and duties are correlative. When we are giving rights to somebody, we have to think about duties also, liabilities also. If there is a mistake on the part of that machine, who is going to do, who is going to give relief to anybody? So that is the reason we are not, means if we go by all these principles, consider all these principles, and then we are coming to the conclusion that artificial intelligence cannot be independently considered as owner from the point of view of copyright I am discussing. Okay, author of the work or ownership of the work, because personhood, which has been discussed, which has been referred everywhere. If you refer to interpretation of statute, all the principles of interpretation of statute, the provisions of Copyright Act is talking about personhood, okay, human touch, and that is what considered under US also. Okay, in the case of infringement, the Supreme Court, the US court has also considered at many occasions that unless and until there is a human touch, we are not going to grant protection. And that is what considered. One more case which we have missed or we have misinterpreted is that of Raghav case, okay, where due to the name or confusion, what was happened initially, the case has filed by the person, I'm not recollecting his name, but Raghav, you must be knowing that he has filed the case, which software which has been used for some work, and by mistake it was rejected because it was software. Then the creator with his name added software as a second author of the work, and then in that case copyright has been provided. But then the mistake has been realized, and then there was a discussion on the part of Copyright Office that yes, we have to revoke it. But when we are talking about revocations, once it is granted, the authorities has to go to High Court, and then revocation is also only possible. See, we have very good jurisprudence, and we are of the opinion that it cannot be granted, it should revoke. But still, the present position on internet is that if you go to provision to website, you will see still the copyright protection has been granted over there. Okay. So that is what I want to talk about, authorship, ownership, when we are talking about with respect to copyright and digitization. Yes, computer program is protected as we are writing some software. But when it comes to artificial intelligence, we are not granting any protection as such. It is not specifically provided, but we are trying to read out. But when we are granting such, we have to think about liability, and we have not come up with those provisions. So completely we have not shifted to it. Then again, I'm coming back to startup. Okay, already we have talked about the various provisions or schemes which has been initiated by the government for facilitating startups so that they can understand what are the intellectual property rights and what will be the consequences of all these infringement of all these rights. Further, here I just want to share with you the challenges and solution to it. When it comes to challenges, now we have challenges with respect to access to the technology. See, it's a rosy picture when we are talking about that government is taking initiative, no doubt about it. But reaching to the last person of the village is very difficult. And though we are reaching over there, then the internet, access to internet is also another issue. So technology is not that much advanced, or it is not so easy to everyone to use it. Okay, so startups are facing these issues, the issue of technology also, then unavailability of credit. See, when we are talking about starting of business, it's not easy. Yes, government is making provisions for it and aware with it. You must be aware about it. But still, reaching to the government, getting those funds, it's a long procedure we are talking about. Many things is to be done. And it is not the thing that it is available to each and everyone. So there is a fight for micro owners also. So yes, then procurement of raw material is also another issue from the angle of startups. Then absence of skilled manpower. See, if I have certain vision to start up, fine, I have that vision, but to accomplish that vision, I need many people, many skilled people. If I am hiring them, I have to pay them. So paying capacity also matters. Many things comes into it. Legal things are also there, but these challenges are also in front of them. Then scarcity of adequate infrastructure, that is also important. Then poor access to the potential market. Unless and until they are well versed with technology, access to market cannot be resolved. So these are the challenges which in a day nowadays we are seeing. But to mitigate these challenges, definitely our government is taking great steps. Then government and policies, okay, which we have to consider. Government should adopt an AI use policy that defines approved tools. Then it should talk about prohibited uses, and help means it gives a way to the people to cope up with artificial intelligence. Also, it required to review legal provisions with respect to artificial intelligence, that platform terms and consider conditions. Then what are the how they are going to overcome with these technological challenges, yes, such type of training or filing will definitely help them. And nowadays we are completely shifted to digitization. When we are talking about registration of intellectual property, all windows are available. But some incubation center, yes, IPR chairs are providing incubation centers also. But to reach those people, that connection has to be established. Sometimes people are not aware about it. So connection to be established, and people should bring bring to the incubation centers or to the centers where such dissemination of knowledge is possible, and our government is doing well into that. Then skill manpower is always problem, but I can say that there is a way, there is a way. So we have to work together, we have to help them to solve such type of problem. And for marketing also, digitization is important. And if we are in a position to help in such a manner, then definitely we can say that startups can well work. That's all from my side. Thank you, Nitin. Thank you, Parul.
Thank you, ma'am.
Thank you, Ragini ma'am. Thank you again for a very insightful session. So, any questions that we may have, please type in the chat box. So we do have first question. So what is the lifespan of copyrights held by a publisher of a book? Is it same with that of the author of the book? Any one of you could take that question, please.
Here again, we can say that when we are talking about book, okay, whatever content has been written, we are talking about that. We are talking about protection of that matter. So when somebody is writing something, it comes under the subject matter of literary work. So copyright will be for the lifetime of that particular author, and after the death of that person, for more 60 years, that work is going to be protected. Because see, moral rights are always there, though copyright has been shifted to publisher. Okay, that will be as per agreement. And whenever anybody wants to use those, yes, of course, they have to take permission from publisher also. Lakshita ma'am will share her thoughts on that. Okay, but at the same time, the legal heirs, whosoever will be there, from them also they have to take permission if something has been used after the death of the author.
So I agree. So if you're asking to answer it very simply, in India it is 60 years after the following year from the year in which the author expires. In the US it is 70 years. And again, we have to see what kind of agreement there was between the author and the publisher. If it was an agreement for assignment of rights, then it will be slightly different from if it was not an assignment but only publishing. If it's only a publishing deal, the copyrights will still vest with the author, and therefore the rights will be counted from the lifespan or the day the author is deceased. In the US it is 70, in India it is 60 years, so just bear that in mind. And also another distinction: in the US, if it's a work for hire, then it will be a fixed period. It will be 95 years or something like that.
Thank you. The next question is, can a program written but modified by a person have copyright? So maybe in other words, a modification of a copyrighted product will that result in further copyright, maybe a renewed copyright? How do you
Sorry,
look at it?
Nitin, can you repeat the question? I'll try
If a
to answer
program
that.
written but modified by a person have a copyright?
Okay, so firstly, if there's a program which is written by one person, let's say Nitin, um, I will need to obtain the rights to be able to create, first license it from Nitin to be able to then create modifications on top of it. If I create modifications, then those modifications will need to be creative enough to then be eligible for being copyrightable. The new work that is generated after that modified work will need to be transformative to be eligible for copyrights for a new copyright.
Okay, thank you. If copyrighted material is used by someone without permission or acknowledgement, what can be done, particularly if the user is thousands of miles away?
You will still need to, and you can still send a letter, a notice saying that your copyrighted work has been used without permission, and that amounts to infringement. It does not matter if the work has been used thousands of miles away. You should still send a note out to say that, your copyrights exist in that work, and therefore you need to be acknowledged for it. Because there are, as ma'am mentioned earlier, there are some related rights with copyright, and one of the related rights, or like an appendix right to copyright, is right to be acknowledged, which is the moral rights that we speak of. Moral rights are non-assignable as per the amendments of 2012 in the Indian Copyright Act, and therefore you have the rights to be acknowledged for your work, even if that the license would have been taken, or even if it is the publisher, they will still need to acknowledge you as the author of that work, and that is what the moral rights mean.
Thank you. If a startup is involved in supply chain performance evaluation and gives out business performance reports similar to DNB report, etc., how do we protect our reports in a manner that LLMs or crawlers do not train on our reports?
So, first of all, if the report has any original and creative content which is copyright eligible, then you can at least put out a copyright notice on that report. That's one. The second point is that if you're looking to avoid crawlers from training on your content or your report content, then you'll have to use technological means. An example that comes readily to mind is like a robot.txt kind of a file, which is appended to usually websites, and that avoids crawlers from training on content from those websites.
Right. Thank you. Depending on agreement between publisher and author, maybe that's a comment on the. Okay, so let's move on to the next question. I think both patent agents and advocates can file copyright applications, right?
Yes, also individuals.
And can we get copyright on handwritten books on any subject correlated purely for academics?
So there are two parts to this. Firstly, I'm assuming handwritten meaning any form that you put your creative original work in, that becomes that qualifies for copyrightability. So whether you type your book or write it in hand, or you type it on a piece of software, it doesn't matter. That's the answer to the first part. The second part, Nitin, can you repeat that, because that's slightly
If the material is collated purely for academics purpose, then can it also become the subject matter of IPA?
Yes, all academic books, all textbooks are also subject to copyrights.
Okay, thank you. All right. Human efforts are there in AI works also, then how it's going to be decided?
So I think I briefly touched upon it. If there are human efforts that qualify to be creative enough and substantial enough to become copyright eligible. For example, you had some extremely unique, creative, original prompts that you used to create a work. Those may qualify for copyright or could be copyright eligible. I can give you the example from the US Copyright Office. The US Copyright Office has a form which requires you to specifically call out in that form and mark out the portions that were AI generated and the portions that were humanly generated or are human inputs, and then they accordingly allocate the copyright eligibility, and the copyright is registered accordingly.
So that's pretty interesting. Okay. Can it be said that ethics is the cornerstone of IP copyright laws? How important is ethics with respect to AI usage today?
Okay, my first response is that ethics go beyond just IP and copyright laws. Ethics is the foundation of civilization, and that is how societies evolve. And because societies evolve in a certain way, that's where the laws are formed. And because laws are formed in a certain way, I think it all sort of circles back, and it becomes very cyclic, and one leads into another.
Yeah, and I mean that will always be around. So yeah, ethics will always be into the consideration. So, yeah. Okay. Does moral rights gets transferred via an agreement to publisher contractor?
No, I think I briefly answered that. Moral rights, as per the amendments of 2012 to the Indian Copyright Act, are non-assignable.
Yeah. How can it be ensured that database utilized by the startups is legally trained? Well, I'm not sure if the question is properly framed, but database utilized by the startups is legally trained. Or you're probably saying if the database has, maybe you can clarify your question again, please. Riya Dev Sharma, please clarify your question. How to prove the content that the content are copied by an infringer, meaning should we submit documents to show that it has been circulated on a medium like website?
Sorry, come again. How to show that it is infringing?
Yeah, how to prove that the content are copied by an infringer, meaning should we submit documents to show that it has been circulated on a medium like website? Again, I guess the question is not very clear. I guess.
Yes, there needs to be some proof, right? Otherwise, how do you know that there is infringement?
Yeah. Yeah, and then the proof can be through your copyright registrations or maybe certain way to demonstrate your ownership. Please share some rules which apply for a work to be copyrighted.
Ma'am, you'd want to take that?
Yes, there they have to refer to copyright provision. That is what I will be saying. And when we are talking about literary work, UGC has specifically talks about those rules. 2018 guidelines are there, so you can refer to 2018 guideline with respect to plagiarism and academic research also.
Thank you. Next is, can we make modifications to already filed software codes or any other work, or should it be filed as a new application? So I guess if the copyrighted material is modified, then does it need a new application or it needs an addendum, or what's the procedure for this?
Actually, it depends. I think it sort of speaks to my earlier, there was an earlier question in my earlier response. If your modification renders it into a new work and is substantial enough, I think it will qualify for a new application. If you're talking of software code, does it have completely new features, functionalities with your modifications? I think then you should file it as a separate application. You can also file amendment if it is only incremental. But if it's only incremental, I don't know if you should even file an application because incremental will anyways be covered with the original application.
Thank you. Guess the next question is, what about the copyrightability of a work where I have written an article and given it to an AI tool to correct it or refine, like Grammarly or ChatGPT?
So that's actually a very good question. If you're saying that you used an AI tool only to correct, let's say, grammar, to correct the syntax, to look at the grammar, then the work is still yours because the substantial portion of the work or the creative portion of the work is all yours. You are only using AI as a tool. For example, before AI, the way we used to use a spell check. That doesn't mean that the work is not yours just because you're running it through a spell check tool. If that is the purpose, the same rules apply as always. The work is copyrightable and you can copyright the work because you're not generating the work using AI.
Thank you. Yes, last one would be, can a mere translation of a book be a part of copyright?
Yes.
Yes.
Translations
Yes,
are
it
new
is.
work, by the way. Under copyright law, translation is a new body of work. And yes, those are copyrightable.
Right. I think with that, we have come to an end. Again, thanks a lot, Lakshika and Dr. Agini, for very insightful sessions. We have lots of great comments and messages. So I'm sure the audience have found it useful. Again, a great topic, ever evolving. So thank you again for all the practical insights that you've shared. It's always a pleasure to listen to you. Thank you.
Thank you, Nitin, for wonderful moderation. Thank you so much for having us here. Thanks. It was great listening to you, Dr. Ragini. And thank you to the audience for being so patient. Thanks, Parul, Kirti, and the team for this.
Thank you, ma'am, and thank you, sir, and thank you all attendees for joining
Thank
this
you.
insightful session.
Thank you all of you,
Thank you.
and particularly participants who has given questions to us. That is important nowadays. They are not silent listener. For that, I am really happy and introducing us to this intellectual minds. Thank you, Parul. Thank you, Nitin. Thank you, Lakshita ma'am.
Thank you. Thank you, Nitin.
With your permission, can we take leave?
Yes, please. Thank you. We'll sign off. Yeah.
Thank you.